Hello everybody, welcome. Today I would like to talk about the institutionalization of business ethics. Let us talk about some laws that protect consumers. Laws that protect consumers require businesses to actually provide accurate and factual information about the products and services and to follow relevant safety standards in a given industry. One of the first consumer protection laws that was passed was in 1906 in the United States. As a result of that consumer protection law, large groups of people with specific vulnerabilities have been granted special protections under those laws, like the older individuals in the society and children, for example, in other vulnerable groups. And in today's environment, for example, the Children's Online Privacy Protection Act, otherwise known as COPPA, requires internet sites to carry privacy statements, obtain parental consent before soliciting information from young children under the age of 13. And they do provide an opportunity to remove any information provided by children using these sites. So again, the children sometimes do not know how their data or information is being used. Therefore, they need to be protected by the laws and by, obviously, adults who are responsible. Also, the Food and Drug Administration regulates food safety, human drugs, tobacco, dietary supplements, vaccines, veterinary drugs, medical devices, cosmetics, products that give off radiation, and other biological products that sometimes can be dangerous for an average person or average consumer in society. There are also laws that promote equity and safety. Laws that promote equity in the workplace were passed during the 1960s and 1970s in the United States, mainly to protect the rights of minorities, women, older individuals, and people with disabilities. And other legislations have sought actually to protect the safety of all workers in all industries. From these laws, probably the most important to business is Title VII of the Civil Rights Act for those of you who are operating in the United States, which was originally passed in 1964, and it was amended actually several times since that time. Title VII specifically prohibits discrimination in employment on the basis of a person's skin color or race, his or her gender or religion, or even national origin or their ethnicity. The Civil Rights Act also created the Equal Employment Opportunity Commission, or EEOC. Also, the Occupational Safety and Health Administration, otherwise known as OSHA, makes regular inspections to ensure that all employees have a safe working environment for them. These are not teenagers necessarily, these are working adults, so these are all workers having a safe environment. Many employees still work actually in unhealthy or sometimes what we consider to be dangerous environments or sweatshops in some cases, in spite of the fact that there was the passage of laws to protect them. But because sometimes competition drives some employers to keep cutting costs and keep pushing people, sometimes employees are being abused, and those employees cannot always leave their jobs, so they basically do not speak up. However, hopefully employees know their rights, so they are not being abused by their employers. Competitive pressures can lead to workplace safety problems, especially in manufacturing, where there tends to be a lot of injuries at times if we take shortcuts, or careless accidents by overworked employees. Let us talk for a few minutes about the Sarbanes-Oxley Act, otherwise known as SOX, S-O-X. The American Congress passed the Sarbanes-Oxley Act during 2002, mainly to establish a system of federal oversight of corporate accounting practices. The Sarbanes-Oxley Act law requires corporations to establish codes of ethics for their financial reporting and to develop more transparency in financial reporting to investors as well as to other relevant stakeholders within that organization. The Public Company Accounting Oversight Board tends to represent actually the heart of the Sarbanes-Oxley. It oversees the audit of companies that are public in order to protect the interests of investors and to further the public interest in the preparation of information that is accurate in independent audit reports for companies. It oversees the audit of public companies in order to protect the interest of investors and to further the public interest in the preparation of informative, accurate, and independent audit reports for all companies within the United States or those that are operating within the United States. The Sarbanes-Oxley Act also seeks to ensure auditors and analysts' independence in order to reduce conflict of interest in this case and to ensure enhanced financial disclosures of these public companies' true condition. So registered public accounting companies can no longer provide both auditing and non-auditing services to public companies because of this conflict of interest issue. It also raised a number of different concerns. For instance, SOX imposed additional requirements in cost on companies. It caused many firms to restate their earnings to avoid penalties, and it still had loopholes actually which executives could exploit that allow companies to engage in misconduct. The Sarbanes-Oxley Act is actually better able to ensure compliance with the enhanced financial disclosures of public companies' true conditions. Sarbanes-Oxley offers whistleblower protection to employees that would prohibit the employer from taking certain actions against employees who lawfully disclose private employer information. However, we need to keep in mind that employees who witness wrongdoing are often still afraid to be whistleblowers because of the backlash and difficulties of finding employment in that industry or outside of that industry in some cases. The national cost of compliance to the Sarbanes-Oxley Act was very, very high. But studies showed that the cost of compliance have gone down somewhat since the law's implementation during 2002. So maybe it's the learning curve, maybe we're better able to satisfy the needs of the law more efficiently. Maybe we start preparing our work at the beginning of the year, so at the end of the year when you're reporting, all your data is there and you don't have to incur additional costs. But nonetheless, the costs have gone down greatly according to the literature. Let us now talk about the laws that encourage ethical conduct in any workplace. Laws and regulations have been passed to discourage unethical decisions and to foster programs designed to improve business ethics and social responsibility. The most important of these laws are the federal sentencing guidelines for organizations, or what is acronymed as FSGO, the Sarbanes-Oxley Act, as well as the Dodd-Frank Act. Actually, the development of reporting systems have advanced quite a bit. Let us dig a little bit deeper into the Federal Sentencing Guidelines for Organizations Act. So the FSGO was passed in 1991 to create an incentive for companies to develop and implement programs that are designed to foster ethical and legal compliance with the regulatory laws in a given environment, or in the United States at least. It applies to all felonies and Class A misdemeanors committed by employees in association with their specific jobs or tasks and responsibilities and work. The Commission delineated 7 steps companies must implement to demonstrate due diligence. So A firm must develop and disseminate a code of conduct that communicates the required standards and identifies the key risk areas for organizations. High-ranking personnel known to abide by legal and ethical standards of the industry should be in charge of the program, so they have more influence. Therefore, they should be having some accountability and responsibility for these compliances because people see them and they have more authority to enforce and communicate and to develop training programs for awareness of these rules and policies. No one with a known propensity for misconduct should be put in a position of authority in the organization. Communication systems for disseminating standard and procedures must be put in place. Organizational communication should include a way for employees to report misconduct without fearing retaliation. In other words, they don't have to be whistleblowers, but they should be able to report the misconduct to the organization without fearing that they will be fired or terminated from their jobs. If misconduct is detected, the company must take appropriate and fair disciplinary actions. After misconduct has been discovered by the managers or by the employees in some way or approach, the company should take relevant steps to prevent those types of misconducts in the future. So those are some of the rules and policies or minimum requirements that the Sarbanes-Oxley Commission required companies to implement as part of their due diligence demonstration process. A 2004 amendment to the FSGO requires that a business's governing authority actually be informed about its ethics programs with respect to the content of the program, implementation of it, as well as how effective it has been. A 2005 Supreme Court decision held that the federal sentencing guidelines actually were not mandatory, but they should serve as recommendations only for judges to use in their decisions. The 2007-2008 amendments to the FSGO extend the ethics training of individuals to members of the board or the governing authority, the high-level personnel in the organization, the employees, and the organization's agent or agents outside of the company. The guidelines had 4 new amendments in 2010. Those amendments included simplifying the complexity of reporting relationships, encouraging companies to extend their internal ethical controls, adding more specific language to the word prompt to help employees recognize what it means to report an ethical violation promptly or as soon as they become aware of it. In amending the extent of operational responsibility to apply to all personnel within the organization's ethics in compliance program. The 2010 amendment also made it possible for companies to have their penalties for misconduct reduced if their ethics program met the conditions. The organization itself must have discovered the misconduct before it was discovered externally or before a whistleblower came forward and reported it to the local or to the federal government authorities. The violation should be reported promptly to regulators. Nobody with operational responsibility can be involved in the misconduct. The compliance officer must have direct access to the governing authority to report misconduct. And in 2014, the Federal Sentencing Commission focused attention on the sharing of best practices among regulatory and law enforcement agencies. So these agencies, such as the Department of Justice's Antitrust Division, are developing compliance programs based on various aspects of the FSGO's 7 steps for an effective compliance program. Let us now talk about some of the core or best practices. The concept of core practices is to focus more on developing structurally sound organizational practices in structural integrity for both financial as well as non-financial performance measures than on individuals' morals. Most ethical issues tend to relate to non-financials, such as marketing, human resources management, and customer relationships in the organization. The use of gatekeepers is one important part of core practices. So gatekeepers are people who must trust and be trusted to make business work properly. And it can include accountants, the financial rating agencies, the financial reporting services, and perhaps others depending on the industry. The goal is that these gatekeepers hopefully are people of integrity, and they should be trusted by both insiders as well as by outsiders in the organization and in the industry. Voluntary responsibilities relate to the business's contributions to all of their relevant stakeholders. And these voluntary responsibilities provide several major benefits to society, including the fact that they improve the quality of life and they make communities a better place where people want to do business, to raise family, and to enjoy life in general. And second, they reduce government involvement by providing assistance to stakeholders. Third, they develop employee leadership skills. And four, they help create an ethical culture in values that can actually act as a buffer to organizational misconduct. There's cause-related marketing, which ties a company's product directly to social concerns through a marketing program over time. With cause-related marketing, a certain percentage of the product sales are usually donated to a cause that appeals to that specific target market. Cause-related marketing can affect buying patterns if consumers sympathize with the cause, the brand, and if the cause is perceived as a good fit, and if consumers are able to transfer feelings toward the cause to the brand. A potential problem, however, is that consumers may perceive a company's cause-related campaign as a merely publicity stunt, especially if they cannot understand the link between the campaign and the company's business practices. There's the strategic philanthropy, which is the synergistic and mutually beneficial use of the company's core competencies and resources to deal with key stakeholders so as to bring about organizational and societal benefits. Strategic philanthropy uses, as all do actually, the profit motive, but strategic philanthropy argues that philanthropy must have a long-term positive impact. Companies that utilize strategic philanthropy often recognize that companies do not operate independently of society, and that improved social conditions could lead to improved economic benefits for everyone, especially the stakeholders of that organization that is involved in strategic philanthropy. To be successful, a strategic philanthropy program should pertain to the mission as well as to the operation of your company, or at least your department in organization's culture or product or core competencies. Social entrepreneurship occurs when an entrepreneur tends to create or establish or find an organization with the sole purpose of creating social value. They desire to find a solution to a problem, to a social issue or concern, rather than to make a profit or to maximize the bottom line for themselves or for others who are investing into the program. These types of social entrepreneurship organizations, also called as social enterprises, can be for-profit, non-profit, or even government-based, or a hybrid of the various categories. The concepts of social entrepreneurship was popularized by the founding of micro-lending organization, Grameen Bank, just a couple of decades ago. Even though its mission is social rather than economic, social enterprises use business-like strategies as well as organizational structures, norms, values, in innovations to reach their social objectives. In other words, they still are in the business of being efficient, in focusing effectively on a specific purpose, and they have to obviously generate income in some cases to fulfill the purpose that they were created for, and to do that in a sustainable manner over time. The major difference between a social enterprise and strategic philanthropy is that while strategic philanthropy is strongly integrated into a company's operations, the organization is not necessarily organized around a philanthropy purpose. Social enterprises, however, directly implement their programs, and they're organized around achieving those social objectives. So what is the importance of institutionalizing business ethics? Well, institutionalization involves embedding values, norms, in artifacts in the organization, in the industry, in a society in general. This way everybody thinks about business ethics or ethics in their behaviors, in their day-to-day conducts. It is very important to recognize that institutionalization of business ethics has actually advanced rapidly over the last 2 to 3 decades, because stakeholders have recognized the need for improving business. We cannot continue selling products or services that are based on false information, based on misinformation to consumers, because sometimes the products that are miscommunicated or mislabeled can hurt a person, and that person has rights to live a healthy life. So when one person is injured or hurt, that is one injury too many, or one person who's hurt or killed that we cannot get back. So companies have to be acting responsibly. So the institutionalization of business ethics is important because we want everybody to behave with strong ethical standards and do what is necessary to protect themselves and other employees and customers in any given society. In other words, the stronger the institutionalization of business ethics, the more we can live according to the golden rule: do unto others as you would have them do unto you. Good luck. As always, remember that ethical behavior is a skill, so you need to personally and professionally police, evaluate, and improve your own ethical muscles, and encourage your employees to do the same, so you all can manage and guide effectively as good leaders in your organization. Good luck.